right, the record will reflect the presence of counsel for the parties. The defendant is present. And the court at this time will share its ruling with the parties relative to the motion for new trial. In this case, on January 6, 2017, defendant filed a motion for a new trial asserting various grounds in support of his request for a new trial. A hearing on the motion for a new trial was set for February 16, 2017. On that date, the defense informed the court that the defense desired to supplement the motion for a new trial based on contact that one of the defense lawyers had with a juror days prior to the hearing on the motion for new trial. Thus, on February 21st, 2017, the defense supplemented the defense's motion for a new trial. The court will address the various grounds raised by the defendant, beginning with the initial motion for new trial. In the motion for a new trial, the defendant initially asserted that he was denied a fair trial on several grounds. The defendant argued that first, there was alleged juror misconduct because a juror called 9 or 10 other jurors to inform them that she had called the court, in this instance the bailiff, because she was concerned with the foreperson's communication to the court the day concerning the fact that the jury was deadlocked. Second, that the jurors did not deliberate during the period of Wednesday, December 21st, 2016 through Monday, December 26, 2016. Third, that the court's exclusion of telephone records of Phaedra Weiss during cross-examination of FBI Special Agent Michael Easter was improper. And fourth, that the prosecution engaged in prosecutorial misconduct during closing arguments. Now, first, as to the alleged juror misconduct, the defendant argues that the juror in seat number 1 violated jury instruction 8.03, and that's a standard number assigned to the jury instruction. Jury instructions are then assembled and given a specific number. At any rate, this deals with this jury instruction deals with the deliberation process. And the argument here is that the juror in question called the bailiff requesting an opportunity to speak to the judge and called 9 or 10 other jurors, informing them that she had called the court, the bailiff in this instance, to request an opportunity to speak to the court. This took place on December 13, 2016, after the foreperson had sent a communication to the court informing the court essentially that the jury was deadlocked. Defendant argues that the juror called the 9 or 10 other jurors to express a desire to continue deliberations. Here the record reveals, as reported by the juror, because the court did address this particular issue and did conduct a hearing providing the juror the opportunity to express the juror's concern to the court. And here what occurred was that the juror was given the opportunity to speak to the court in the presence of the attorneys and on the record. And the juror reported to the court the following concerning the communication, and that is the juror stated that the final communication that came through yesterday, that's December 13, 2016, was not even revealed to the jury, our entire panel. It was basically just written, and when there was a question about what's on it, it was read and ran out the door. So the content was not how the majority, and we did express that we needed more time. There were numerous requests. It was noted that the decision was not going to be changed. We could sit there for months and nothing was going to happen. Our concern was not to change it, but we just wanted more time to examine it, which we hadn't. Now, prior to the juror sharing this with the court did meet with the attorneys and on the record, the court did inform the parties prior to this meeting with the juror at the bench that if the parties were of the view that they would wanted to request an in-camera hearing, they could inform the court. And after the juror expressed this concern at the bench, the court did provide an opportunity to both the state and the defendant to question the juror, as well as any other member of the jury. Now, after sharing the information that the court just read, that the juror shared, the juror indicated that she called and informed everybody that she called the court and expressed concerns about what had happened yesterday. And again, when she's referring to the court, she's referring to the bailiff. At any rate, the court did, after the juror shared this information, the court did give the parties the opportunity to ask questions of the juror. Both the state and the defense declined to ask questions of the juror. They were satisfied with the information that had been shared and satisfied with the proposed communication in response to jury communication number 19, which essentially expressed that the jury was deadlocked. And that response is a basic and standard response to communication of that nature. The parties agreed to the following response to the jury: would further deliberations assist the jury in reaching a verdict, or are you hopelessly deadlocked such that you are unable to reach a unanimous verdict as to both counts? And the court did provide the parties the opportunity to revise that communication. However, the parties were satisfied with that communication. The defense approved the communication, and it was sent to the jury, and obviously the jury chose to continue with its deliberations. And indeed, the jury systematically, after this, as the record does reveal, carefully examined the record here. The jury made numerous requests to examine transcripts. Jury, following this particular communication, asked for the ability to examine a number of transcripts of witnesses. Those transcripts, of course, had to be prepared. Most of those transcripts were not, had not been prepared as of the time of the request. So subsequent to this communication, the jury made requests for a total of 8 or 9 other transcripts over the course of their deliberations, This began on December 14, 2016, and culminated with the jury at 10:20 in the morning of December 28, 2016, informing the court that unanimous verdicts had been reached, and it was then agreed that the verdicts would be received by the court on December 28th at 1 p.m. The parties agreed to that process, and that communication was sent to the jury. And ultimately, the jury found the defendant guilty of the 2 charges in this case, and then the case then proceeded on to a second phase after that. Now, with respect to the arguments concerning jury communications, the defendant asserts that there was jury misconduct rising to the level that questioned the impartiality of the jury, and that the court is required to grant a motion for new trial, arguing that the jury was not impartial, and that the failure to do so would constitute an abuse of discretion on the part of the court. The Supreme Court of the State of Hawaii has addressed issues related to this type of concern and argument in the past, and the Supreme Court of the State of Hawaii has clarified the process by which the trial court is to examine issues of this nature when such an occurrence is raised, as it was by the juror seated in seat number 1 during the deliberations. And the court has indicated and stated that there is a process for the court to determine whether the general nature of the misconduct could substantially prejudice the defendant's right to a fair trial. That, of course, was stated in the case State versus Chin, 135 Hawaii 437, decided in 2015. And the court explained that the court first examines the general nature of the alleged misconduct, and if such misconduct is generally of the nature that could substantially prejudice a defendant, the trial court is required to investigate the totality of circumstances surrounding the issue. And in its determination of possible substantial prejudice, the Hawaii Supreme Court has noted that a new trial will not be granted if it can be shown that the jury could not have been influenced by alleged misconduct. And thus, in fact, it must first be shown that 1, the comment was improper, and 2, that the comment was used as a circumstance against the defendant. Here, the concern raised by the defendant is, as I've mentioned, twofold. 1, that the juror called the bailiff to state that the juror wanted to speak to the court about the juror's concerns, and that the juror informed fellow jurors that she had done so. When the court applies that to the specific report made by the juror and the specific conduct, as well as the tests that the court is supposed to follow in evaluating issues of this nature, the court would first look at the general nature of the alleged misconduct to determine whether it substantially prejudiced the defendant. Here, the general nature of the alleged misconduct relates to a desire on the part of the juror to at least explore whether further deliberations would assist the jury in reaching a verdict or verdicts. And as a matter of general course, when a jury does express an indication that the jury is deadlocked or unable to reach a verdict, typically the court, and in this instance the court with the consent of the parties and with full knowledge of the parties, asked that very question. And the jurors, including the foreperson who also specifically addressed the court, subsequent to this juror addressing the court, the jurors were of the view that further deliberations would assist them, that they were not hopelessly deadlocked, and they continued the deliberations for several days and made a number of requests to fully examine the record. The jurors deliberated extensively during the month of December and obviously carefully considered the record and ultimately reached some 14 days later a verdict, or verdicts in this instance. In the court's view, the nature of the alleged misconduct, the desire to speak to the court, to let the court know that the juror was concerned about whether the jury was in fact hopelessly deadlocked, is not of the nature that would substantially prejudice the defendant. Indeed, it is of the nature, it is something that the court and the parties would have expected the court to do, and that is inquire of the jury as to whether they were hopelessly deadlocked. The court did so, and the jurors were not, and continued their deliberations. They did not reach a verdict immediately thereafter, but continued to carefully examine the record and ultimately did reach 2 verdicts. In the court's view, with respect to the initial inquiry, the court is of the view that the general nature of the alleged misconduct was not of the type that substantially prejudiced the defendant. I will note that the juror did not, there is no indication on the record of the juror continuing deliberations with fellow jurors, but rather informing fellow jurors that she would be speaking to the court about her concerns. And that is exactly what she did. And the parties were given the opportunity to examine the juror relative to this. It seems quite clear to the court, and I at the time quite clear to the parties here, that asking the jurors whether further deliberations would assist them in reaching a verdict, or whether they were hopelessly deadlocked, was the obvious and reasonable approach to take in light of the communications received to the jury, from the jury. That's what was done. Verdicts were reached. Understandably, the defendant is not in agreement with the verdicts reached. The court can appreciate that, but when applied to the standard that has been set by the Hawaii Supreme Court, that does not give rise to the grant of a new trial, given the nature of the communication. All right, now, even if the court were to assume for a moment that the communication by the juror constituted inappropriate misconduct, here the record would not support that the circumstance was one that was used against the defendant that would rise to the level of examining what occurred here, and would have caused the court to have to embark on some other course of conduct. And I will note for the record that at the time that this occurred, and of course this is all occurring prior to verdict, at the time the court did give the attorneys the opportunity not only to question the juror's seat in seat number 1, but any other juror who was deliberating, and the parties declined the opportunity to do so. So based on the standard that the Hawaii Supreme Court has set forth in terms of how the court is to evaluate matters of this nature, the court is of the view that the law and the facts here, the actual record, clearly do not support the grant of a new trial based on what occurred during deliberations during December 13th and 14th of 2016. Next, the defendant argues that the quote-unquote jury separation that occurred during the period of December 21st, 2016 through December 26, 2016 supports a finding and conclusion that the defendant should be granted a new trial. Here, there was a recess in deliberations from December 21st, 2016 through December 26, 2016. The court will note for the record, although I think it should be obvious, but it hasn't been argued by anyone, although it has been mentioned in the pleadings. Just as a reminder, December 21st was a Wednesday, December 22nd a Thursday, December 23rd a Friday. Those are the 3 days preceding the Christmas weekend. And December 24th, 25th, December 24th was a Saturday, Christmas Eve, December 25th, Christmas Day, and December 26th, a holiday, inasmuch as Christmas fell on a Sunday. So, regardless of any circumstance, the jury was not going to be deliberating for half of that period because the jury and the court and the parties would be engaged in the Christmas holiday, as was everyone else. And it is also appropriate to remain mindful of the fact that this jury had been serving for several months. The trial, the jury selection process began on May 23rd, 2016, and the jury was in deliberations on December 20th, 2016. And it certainly, in light of everything that the jurors were going through in terms of examining the record, requesting transcripts, and having been engaged for, at this point, over a half a year with the trial, certainly, in the court's view, appropriate to give the jurors some time to enjoy the Christmas holiday with their families. Now, the defendant argues that, in part, that the jury was permitted to recess deliberations for approximately 1 week, and that the unannounced recess came after the jury announced that they were unable to reach a verdict in a case where it was virtually impossible to avoid hearing news reports of public opinion. And respectfully, the court does note, and as the record bears out, the jury communication concerning the inability to reach a verdict occurred on December 13th. The desire of the jury to proceed with deliberations took place on December 14th, and from that point on, the jurors continued actively examining the record and making requests for additional transcripts and the opportunity to continue to examine the record. The jury deliberated on December 14th. The jury deliberated on the 15th, the 19th, the 20th, and as indicated, the jury was given time to enjoy the Christmas holiday, and as indicated, half of that period of time there would have been no deliberations under any sort of set of circumstances because of the Saturday, Sunday, and Monday holiday following Christmas. Now, it is argued that and the defendant does state that the standard with respect to the separation of a jury during deliberations does not constitute prejudicial conduct as a matter of law, but is simply a circumstance with other circumstances that ought to be taken into account by the court in determining whether or not a new trial should be granted. And here I think it's important to note that the case relied upon by the defense, Aloha versus Tanaka, 45 Hawaii 457, 1962, involves a case in which there was separation of a jury following an order that the jury be segregated. And that's clearly distinguishable from what occurred here. And I will note, and it's clear from the record, that at no time did either party request that the jury be segregated. The Supreme Court did hold that it shall not be necessary in any case, whether civil or criminal, for any trial after having been finally accepted and sworn to, any trial jury after having been finally accepted and sworn to try the cause to be segregated, locked up, or otherwise confined at any time prior to retiring to deliberate upon the verdict. The defense never requested segregation of the jury, nor was the jury ever ordered the segregation in this case. And as such, the arguments relative to the prejudicial effect of separation here are quite distinguishable from the authority relied upon by the defense, and not in the court's view of application to the fact pattern that we have here. The Supreme Court of the State of Hawaii has considered the possible prejudicial effect of suspension of jury deliberations, and did previously hold that a 17-day suspension of jury deliberations was not prejudicial. That in State versus Kanai, 89 Hawaii 198, a case decided in 1998. And the court in that case went on to explain that such a lengthy hiatus in deliberations was not unprecedented, and when a trial court had a legitimate reason to recess deliberations, there was no resulting violation of the defendant's due process rights. And the Supreme Court of the State of Hawaii bases its determination on a number of factors, including the length of the trial, and in this case, the length of the trial certainly supported a brief deliberation. The Christmas holiday, in the court's view, certainly supported a brief recess in deliberations. And the recess itself was not in any way, shape, or form violative of any type of statute, rule, or court order. And the court had repeatedly reminded jurors throughout the entire trial of the case of the rules related to not reading, watching, or listening to any news accounts. That had been done many, many times throughout the trial. There's nothing in the record to support other than mere speculation, and that doesn't support anything. Mere speculation that the jurors might have been somehow exposed to and have actually read news accounts or watched news accounts about the case. There's absolutely nothing on the record to support that. And and I will note that I do realize that the parties and the court in having this case, that is the #1 priority in terms of the court and the attorneys. But I think it's unrealistic to expect that jurors surrender their entire lives to jury service. I can understand how the parties would be completely involved and consumed by the trial process, and certainly these jurors gave a great deal of their time to this, and I think it would be unrealistic, inappropriate, and unfair to not allow the jurors to enjoy the Christmas holiday. As a result, I do not see the record, the case law, and the facts of this specific case supporting the request for a new trial made by the defense. Next, the defense argues that the defendant should be granted a new trial because the court did not allow the exclusion of cell phone records of Phaedra Weiss during cross-examination of FBI Special Agent Michael Easter. The defense did seek to have these records admitted as part of the cross-examination of Special Agent Easter. And while there was a great deal of discussion about it, I want to initially note that the court was never of the view that the actual phone instrument needed to be examined. I'll state the obvious. Obviously, Carly Scott's phone was never recovered, and the court did allow testimony concerning those phone records that had been examined and analyzed by Special Agent Easter, and that were discussed during the direct examination of Michael Easter following a 104 hearing to make sure that he was properly qualified to present such evidence. The court's reference to phone obviously is a reference to phone records, and the court will just note that for the record. The testimony concerning Phaedra Weiss's records clearly were beyond the scope of the direct examination of Special Agent Easter. Indeed, the court had been asked to exclude some of his work based on late disclosure. The court, similar to the DNA evidence, did exclude that additional evidence that had been the subject of late disclosure. I did, on more than one occasion during this trial, remind the parties that all of these witnesses were subject to recall. Indeed, the defense did, from time to time, express a possible intent to recall certain witnesses. Here, Special Agent Easter testified roughly halfway to 2/3 of the way into the trial. There was ample time, indeed weeks, during which there was an opportunity to recall him if there was a desire to do so. He was not recalled as a witness by the defense. The court would have allowed that. And we're talking about evidence that the defense wanted to present relative to a different set of phone records. And I will also note that here the defense did, long before trial, request the opportunity to secure their own expert in this area. The court authorized that, and such a person was hired, worked on the case, and was paid, and the defense elected not to call that individual as a witness. And that's a matter of trial strategy that the court is not questioning. When a defense can consult with an expert, have an expert do a workup in a case, and choose not to call that expert, and that's perfectly acceptable trial strategy. And that can be done for any number of reasons. I'm not going to speculate on that, but that can be done for any number of reasons. But at the time, given the scope of Special Agent Easter's direct examination, and given the manner in which the request to introduce the phone records of another person, Phaedra Weiss, was made, in the court's view, denial of that request at that point in time is supported by the rules that relate to this. Hawaii Rules of Evidence, Rule 611, does provide that as it relates to the scope of cross-examination, a cross-examination should be limited to the subject matter of the direct examination and matters affecting the credibility of the witness. The court may, in the exercise of discretion, permit inquiry into additional matters as if on direct examination. Here, the court was of the view, although I do understand that the defense wanted to attempt to attack the credibility of Special Agent Easter, the court was of the view that that was outside of the scope of this testimony, and indeed the defense had limited or narrowed the scope of that examination, and such that the court kept it to that scope of examination, and the parties had the opportunity to recall him, or to call the defense had the opportunity to call their own expert on those matters, and chose not to do so. Here, in the court's view, this does not give rise to an argument that there should be a new trial granted.
Your Honor, I'm sorry for interrupting, but I can see that the state's not going to make this correction, so I feel compelled to offer a correction here, in as much as the proffered phone records were never proffered during cross-examination of Special Agent Easter. It's an anachronism, I think, on the court's part. It was attempted to be brought in during, I think, rebuttal or re-cross or something of and based on stipulation at that part. So
Okay, I do recall that discussion as well. Thank you for.
But we had in no way tried to introduce this during the cross-examination of Special Agent.
Okay, actually, all right.
Right.
I actually thought that you, in part, were attempting to do that, but thank you for correcting me. I appreciate that, and I'll certainly accept that. I do know there was a discussion about whether or not the parties had reached an agreement relative to the records that were going to be presented. With respect to that, that would have been presented without any type of. You're talking about the records that you wanted to.
Basically, Phaedra Weiss's phone records.
Right. That there was a discussion about the introduction of the records, and then when it was discovered by the defense that the introduction of the records went beyond the scope of what was intended, because I had asked I believe it was Mr. Nardi specifically, and maybe you. Okay, it was you then. All right. I had asked you about the scope of the purpose of those records, and you had limited it to that, and then that position changed. Right, and then you changed it. Right, and
my point in interrupting the court was in as much as the court's basing this ruling on the premise that we made this attempt during the cross-examination of Special Agent Easter and all the implications that followed from that premise, I will just submit that that's completely misplaced. We never tried to do that.
Thank you very much for correcting me on that. I appreciate that. So let's get to exactly what was discussed then, and that is there was an understanding reached as to what the records would be used for, and when it became evident to the prosecution that those records in question were going to be used for another purpose, a dispute arose with respect to that, and as a result, there was no understanding with respect to those particular records, and given the record at that time, including any foundation required, it would have been inappropriate for the court to have allowed that. But in that particular instance, if that's the sole focus of this argument, then in the court's view, the denial of that is not such that it rises to the level of the grant of a new trial. If I will say that if the defense wanted to present that in relation to cell tower information, then what the defense could have done was either recall Special Agent Easter or call their own expert that had been hired by the defense. And neither of this was done. And frankly, in this particular instance, the prosecution and the court was led to believe that the records were being introduced for a limited purpose. And when it became, when the court was speaking to the parties about this, it became evident. And I guess the reason I'm remembering Mr. Nardi is because I believe you were conferring with him at the time, but that it became evident that the use of this information was not as initially represented to the court. The court did not allow that. But nothing in the record really supports the court's nothing here would support a conclusion that the court actually denied the defense the opportunity to present this evidence, because it could have been presented by way of recalling a witness or calling the defense's own expert who could have testified to these records. And in the court's view, this does not give rise to a grounds for a new trial. So to the extent it might, well, Mr. Uppo is representing to the court that it has nothing to do with Special Agent Easter's testimony at all, and it's solely related to the what was represented to be the restricted use of the records in question, and what ultimately developed was the intent of the defense to argue from those records cell tower information. In the court's view, the defense made a trial strategy call to do it the way they did it, and that was to attempt to get the records in, and then to allegedly for one purpose, and then apparently with an intent to argue otherwise during the closing arguments. And in the court's view, that does not constitute grounds for a new trial. Now, with respect to the last argument as to the initial motion, the defendant argues that the prosecution engaged in prosecutorial misconduct in its closing arguments, and here, in terms of the arguments of the defense, the statements made by the prosecutor in the closing arguments concerning the number of bones recovered at the scene were objected to, sustained, and stricken from the record. The state did correct its argument here that the jawbone was the largest piece of bone that was recovered. The state, it is also argued that the statements and arguments of the defense related to the decedent speaking to the jury through her jawbone was objected to. The court sustained the objection, and that was ordered stricken from the record. A prosecutor's remarks are generally considered cured by the court's instruction to the jury, and because it is presumed that the jury will abide by the court's instructions. And here, the arguments that are complained of by the defense are arguments that were objected to. The court did sustain the objections, and the court did order those stricken from the record. And the jury was instructed not to consider in their deliberations any matters stricken from the record. In the court's view, this does not give rise to the grounds for a new trial. As previously noted, the motion in question was the motion for new trial was supplemented by a supplemental pleading filed February 21st, 2017. And with respect to that particular argument here, the defense asserts that, by way of counsel's presentation, that a communication between counsel and juror number 3 revealed that the jurors engaged in an experiment during deliberations, that experiment being looking at the size of the genes received in evidence and determining who could have worn those, and also a discussion concerning conclusions regarding the mechanism of injury that caused the injuries to Mr. Capobianco's hands. It is argued that this constitutes non-record evidence and juror misconduct, and should result either in the court examining the juror or the jurors, or the court granting a new trial. The Supreme Court of the State of Hawaii has held that in order to grant a new trial, it must be shown, as previously noted, that the juror comment was improper and that the comment was used as a circumstance against the defendant. Now, and once a court has determined that the defendant's burden to prove these two factors has been established, then such that the defendant's right to a fair trial by an impartial jury was jeopardized, in other words, denied, then a rebuttal presumption is raised, and the trial court is then duty-bound to further investigate the totality of the circumstances surrounding the alleged deprivation to determine the impact on the jury impartiality. So the two instances raised by the defense first would relate to the statement that the juror seated in seat number 3 used his or her professional or her personal professional experience to conclude that the injuries to the defendant's hands were ligature marks caused by the defendant strangling the decedent, Ms. Scott, with a rope or wire, and that this was shared with the fellow jurors. So that is the first instance, and then the other related to the argument that jury misconduct occurred when the jurors positioned one juror claimed to be 6 feet tall next to the bailiff while the bailiff was holding the pair of blue jeans in question, and that they then concluded that based on that experiment, the blue jeans could have or did fit Mr. Capobianco. Hawaii Rules of Evidence, Rule 606B, provides that the court cannot consider the juror's testimony as to the effect of any improper statement upon them. Indeed, the public policy demands that the sanctity of jury deliberations be vigorously guarded, and the Hawaii Supreme Court has recognized this prohibition against a juror testifying as to the internal deliberations of the jury. The court can only consider whether such a statement was made and whether, given that statement, whether it can be said that the defendant's right to a fair trial have been denied. It is improper for the court and in violation of the rules of evidence for the court violates the rules of evidence as well as public policy and Hawaii Supreme Court precedent to permit the questioning of jurors regarding the internal deliberations of the jury. In State versus Kim, this very subject was discussed by our Hawaii Supreme Court. And this is found in 103 Hawaii 285, a case decided in 2003. And the court went, in that particular case, discussed in some detail the importance of the sanctity of jury deliberations. And in referring to the jury conduct in that case, State versus Kim, the court noted that assuming arguendo that juror 10's statements were improper, Kim would still be required to show how these statements were used as a circumstance against him. Pursuant to Hawaii Rules of Evidence, Rule 606B, Juror 7 would not be allowed to testify as to the effect of Juror 10's statements had upon her. As such, this court may not consider Juror 7's belief that Juror 10's statements influenced her decision. Because Kim's offer of proof made no other showing as to how Juror 10's statements were used as a circumstance against him, his offer of proof was insufficient to warrant an evidentiary hearing. As such, based on the facts and circumstances in the instant case, that being the Kim case, we hold that the Circuit Court did not abuse its discretion by denying Kim an evidentiary hearing on his motion for a new trial based on juror misconduct. The court went on to state, also of much importance, public policy demands that the sanctity of jury deliberations be vigorously guarded to ensure frankness and open discussion. It would be fatuous to expect or necessitate that all jurors be placid and composed during jury deliberations. Jury verdicts are reached only after open discussion, some of which may be assertive, contentious, and even offensive. In 1915, the United States Supreme Court, albeit in a civil case, described the rationale supporting prohibition against a juror testifying as to the internal deliberations of the jury. And the Kim court quoted the following from that United States Supreme Court case. And the quote was, "But let it once be established that verdicts solemnly made and publicly returned into court can be attacked and set aside on the testimony of those who took part in their publication, and all verdicts could be, and many would be, followed by an inquiry in the hope of discovering something which might invalidate the finding. Jurors would be harassed and beset by the defeated party in an effort to secure from them evidence of facts which might establish misconduct sufficient to set aside a verdict. If evidence thus secured could be thus used, The result would be to make what was intended to be a private deliberation the constant subject of public investigation, to the destruction of all frankness and freedom of discussion and conference. The law is settled that following dispersal of a jury, once it has been dismissed, if we allow such attacks by individual members, and by the way, this is the Hawaii Supreme Court speaking now, quoting another case, if we allow such attacks by individual members on the composite verdict of all 12, we can expect an unsettling of the system out of all proportion to any expectable improvement in the administration of justice. Here the Supreme Court, the Hawaii Supreme Court, was quoting a federal case out of the and also well, two actual cases. And the court went on to state, allowing inquiry into the effect of internal matters of jury deliberations upon the mental process of particular deliberating jurors would discourage open discussion among jurors and severely impact the finality of judgments. Thus, public policy supports our holding in the instant case. Here, if we talk about the marks related, the marks on the defendant's hands, clearly that was something that the parties had argued about during the course of the trial through its examination of the evidence during the course of the trial. I'm not suggesting that the parties were arguing ligature marks, but clearly that was a subject of some discussion and presentation of evidence during the course of the trial. In this particular case, in the Capobianco case, photographic evidence depicting the injuries to the defendant's hands was introduced into evidence. Assuming that a juror in seat number 3 verbalized her observations and impressions of the injuries, in the court's view, was neither improper nor was it obtained from an outside source. Similar to the Kim case, where a juror discussed his knowledge of firearms and firearm ammunition and the type of damage that could be caused by firearms, in the court's view, the jurors, given the presentation of the evidence during a trial, not surprisingly, looked at the injuries to the defendant's hands and may have drawn some conclusions relative to that. The fact of injury or the lack of injury or the cause of injury to the defendant's hands, not an element of the offense. It was not something that the prosecution was required to prove, and in the court's view, does not give rise to the grant of a new trial. As the Hawaii Supreme Court has noted, it is perhaps inevitable that during jury deliberations, jurors may verbalize, based on their background and experiences, their perceptions. And if the statement of counsel is correct in terms of what juror in seat number 3 said, in the court's view, that does not give rise to a new trial. And conducting an inquiry concerning what the juror's impressions were concerning the evidence and the deliberation process, in the court's view, is prohibited by rule as well as by public policy and precedent of the Hawaii Supreme Court. And and as a result, the court is not going to allow that to occur. And as Mr. Opposed indicated, that creates the perfect appellate record for them. So be it. The other instance of alleged jury misconduct relates to the asking the bailiff to hold the pair of jeans while someone who allegedly indicated it was 6 feet tall stood next to them to determine whether that person could have, or whether the person of that height could have worn the jeans. Again, this hardly relates to an element of the offense. Frankly, anybody committing an offense can wear anybody's clothing for any number of reasons. Certainly, they could wear their own clothing, they could wear somebody else's clothing, they could wear clothing that fits them, they could wear clothing that doesn't fit them. In the court's view, having the jurors observe a particular piece of evidence that had been admitted to trial and drawing reasonable conclusions from their observations does not give rise to a new trial, and is part of the integral process of deliberation. And by the way, I will note that there's no allegation here that there was any deliberation in the presence of the bailiff, who was simply holding the jeans for the benefit of the jurors. Accordingly, based on the foregoing, the court is going to deny defendants' motion for new trial filed herein on January 6, 2017, and supplemented on February 21st, 2017. The prosecution is instructed to prepare the appropriate order. Thank you. We are in recess.